And Terrell, the state Supreme Court upholds the Protect Illinois Communities Act banning assault weapons. The High Court found that the ban does not violate constitutional rights.
Judicial bias is now being claimed against the Illinois Supreme Court. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like the channel, like the content, and what I do here, you can support me with the link. Everything is appreciated. Once again, to my Connecticut residents, here's your public service announcement. If you want to get a Connecticut pistol permit, please get the training completed before July 2024. Do not wait. The state has changed the requirements for training to obtain that permit, made it longer, harder, and more expensive. No other reason than to disincentivize the individual from going out and getting their permit to then be able to purchase a firearm. Also, to the people who have your permits, watch that expiration date. Do not rely on the state to send you that renewal notice in the mail. Don't let it expire. Let's talk about this. Now, as we know, we have the Illinois Safer Communities Act, which is under fire in the courts as unconstitutional. And we've seen some progress back and forth with this. One court says it's good to go. Another court says, no, it's not. But what has now come up is that there's claims of bias in the Illinois Supreme Court, as two of the justices have come under fire, claiming that they have a specific bias against persons owning assault weapons, and claims that they are being funded by Governor Pritzker. Let's come into here. Illinois shows disinterest in judicial conflict challenge as more evidence emerges. Quote, judicial system reeks with Democrat political bias against guns and more, Amalan reported November 29th, recounting original documentation by rights advocates at the Moms at Arms website showing two Illinois Supreme Court justices who ruled on a challenge to the state's assault weapons ban were enthusiastic gun control supporters and received substantial political contributions from lawsuit defendant Governor Jay Pritzker. Now, I can tell you right now, I'm not surprised. In no way, shape, or form. I've argued in past times that judges do not rule based on the Constitution. They actually rule on their biases. So I'm not surprised there at all. But corroborating those charges was another petition, one filed by State Representative Dan Calkins with the United States Supreme Court seeking review of the Illinois court's decision, per a Newsweek report citing WRSP-TV. Quote, the petition argues that Justices Elizabeth Rochford and Mary Kay O'Brien participated in the case despite receiving campaign contributions for those who support the ban. Both Justice Rochford and O'Brien received disproportionate campaign contributions and both made a commitment to support the legislative policy of banning assault weapons. Okay, two developments have been added to the SCOTUS document since then. First was a waiver of right to respond filed on December 1st by Illinois Solicitor General Jane Eleanor notes, quote, I do not intend to file a response to the petition for a writ of certiorari unless one is requested by the court, she wrote. I'm filing this waiver on behalf of all respondents. Then December 4th, Calkins and petition filed a supplemental brief to petition for writ of certiorari, maintaining, among other things, quote, newly discovered material by Calkins discloses $7,300,000 additional to the $2.6 million direct financial contributions in the original petition, indirect campaign expenditures supporting the candidacies of Justices Rochford and O'Brien by a political committee backed by defendant Illinois Senator President Don Harmon. The expenditures for the benefit of Justices Rochford and O'Brien were concealed from the public until 7 months after the election. Neither Justice Rochford nor Justice O'Brien disclosed or otherwise acknowledged the All for Justice expenditures supporting their campaigns originating with one of the defendants, including his counsel of record in this case, when issuing their orders denying the motion for recusal disqualification. Wow. Yeah. So basically, they were funded to have a certain opinion on the assault weapons ban. That's basically what this argument is saying. And it's, wow. But like I said, I'm not surprised. I may seem surprised, but I'm actually not. This is pretty much par for the course. But obviously they're going after them for this because apparently there is bias, not only political bias, but also it seems to be financially backed bias to vote a specific way on the assault weapons ban in favor of the defendants, being Pritzker, and all those who support the ban. And that's very disturbing. That's very disturbing. Now, I breathed through this story, looking it over, and now I'm digging into it more and more. There's more and more information coming up about these two judges and what they did. And basically, you could argue very easily that they had financial influence as well as political and social influence to vote a specific way, which means they're not apolitical or non-biased in their opinions. But we're going to keep an eye on this and see how this writ goes forward to the court, because it's going to the court, Supreme Court, to then have these two judges. I think it's going to overturn their decision, but we'll see. We'll see how it plays out. But it's very, very interesting. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.